Privacy is not a partisan cause. It's a foundational American promise. The freedom to live, work, and participate in civic life without constant government scrutiny underpins everything from the right to bear arms to the confidentiality of our tax records. Americans expect their personal information to be protected, not monitored, not weaponized. As Arizona's chief election officer, it's my duty to safeguard that privacy, especially when it comes to voter data. In the early 1970s, Americans learned a hard truth. The federal government had been secretly building files on its own citizens, using that information for political advantage. The revelation led Congress to pass the Privacy Act of 1974, a landmark law establishing clear limits on how government can collect and use personal data. The message was simple but powerful. Never again should information gathered by government be used to intimidate, silence, or punish. Those lessons aren't just history, they're warnings. Federal agencies once spied on civil rights leaders, anti-war protesters, and journalists. People lost their jobs or were blacklisted, not because they broke the law, but because they held unpopular views. Congress responded by demanding transparency, accountability, and consent before personal data could be used. Today, technology allows vast amounts of information to be shared in seconds. That efficiency can be useful, but it can also be dangerous. When the federal government requests access to the sensitive personal data of millions of Arizona voters without a clear legal purpose, I have an obligation to say no. That's not obstruction, it's law. It's the Privacy Act doing exactly what it was designed to do. Unchecked access to personal data is not efficiency, it's power. And in our republic, power must always be limited and accountable. That's why I will continue to stand by the Privacy Act of 1974 and continue protecting the personal information of every Arizona voter.